So thank you very much for joining us today. For those of you who don't know me, Kirsty White, and I'm joined by Natalie Kearney. And we are both junior members of the St Philip's Business and Property Group. And we're going to talk to you this morning about the business interruption test case that's highly publicised, and we've seen a lot about it in the media, and there's been a lot of talk about it. When we were deciding on a date for this seminar, we thought today was Friday the 13th, so we did go for a bit of a clever play on our title, which didn't quite come off, but we do still think there's some areas where the test case is slightly unlucky for some, and we will go into that in a little bit of detail. So the case is, for those of you who want to go and read it yourselves, the Financial Conduct Authority and others, and Arch Insurance Limited and others. So Natalie is going to start off taking us through the case this morning, pulling out the key points, and discussing the various elements of the policies that the court went through. I will then go through the practical implications and our sort of observations and what we think that might mean for certain things. And then we're going to leave a little bit of time at the end for some question and answers. If throughout the webinar you've got a question, if you want to pop it into the chat function below to all panellists, both Natalie and I can see that. And then we'll have a little bit of roundup of those questions at the end. I should caveat though, we're not going to be answering any questions on specific wording. So if you've had a client come to you and they've got a specific point, purely because we think that might be a little bit more in depth than just answering it on this webinar. By all means, if you've got any specific questions that you want to ask us, then we're more than happy for you to contact either of us after the webinar. So I'm going to hand over to Natalie, who's going to take us through the case.
Thank you, Kirsty. Morning, everybody. So just by way of background then, really, to get us started out. So what is the case for those of you that have been living in a hole since probably June last year when it all kicked off, and January this year when we got the Supreme Court judgment? So there was a framework agreement between 8 insurers and the FCA, which started in June of last year. And it was the Hiscox Action Group then later were permitted to be interveners. And the aim was to have a test case before the commercial court, which commenced in June again of last year. And there was an expedited trial because of the importance of the issues that we're talking about here. Obviously, the pandemic was, and everyone will be bored of this word, unprecedented. And it left us in a bit of a situation as to what the impact would be for policyholders with business interruption insurance. And so in the case, the parties sought declarations about the meaning and the effect of relevant policy wordings. They sought to give a really broad example of different insurance policy wordings, so that the court could give as broad a possible set of guidance, essentially, for policyholders and insurers moving forwards. So the first instance case was heard by 2 judges, as is permitted under the test case scheme, and they gave their initial judgment on the 15th of September of last year. It ran to some 580 paragraphs, so it was quite a comprehensive judgment, and as anyone would expect, it was then leapfrogged to the Supreme Court on appeal, given, again, the nature of the issues involved. And there was a unanimous judgment handed down on the 15th of January of this year. I say unanimous, there was a slight differing between the majority of 3 and 2 of the other judges, justices, forgive me, but there was a very minor point in the reasoning, but for our purposes, we'll look at the majority reasoning given. So in terms of the key issues, what was the court actually looking at? Well, it was firstly the proper interpretation of 4 types of clauses, and then looking at causation. The 4 clauses that we were looking at were disease clauses, by which we mean, I've got an example there on the slide. We shall indemnify you in respect of interruption or interference with the business during the indemnity period following any occurrence of notifiable disease, for which there's a definition, or occurrence of notifiable disease within a radius of 25 miles, so at the premises or within a specified area. So that's the disease clauses we're going to be talking about, and that's how the court categorised those. And then there were prevention of access clauses, so your typical, because of a restriction imposed by a local authority, access is prevented, waiting to that effect, or hybrid clauses, and that's the example you see there on the screen. Loss as a result of closure or restrictions placed on the premises, as a result of a notifiable human disease manifesting itself at the premises or within a radius. So it sort of combines the prevention of access and the disease clause. And then the fourth type of clause was these trends clauses, which include pre-trigger losses. We'll look at those in more detail as we go on, but essentially it's the way that the insurer quantifies the policyholder's loss. I mean, in terms of causation, there are some interesting comments by the judges on deficiencies in what we all know as the but-for test, which I will come on to in some detail as we carry on. So how did the court interpret clauses in these policies? So disease clauses. In the first instance decision, there was quite a broad interpretation of what was meant or what could apply as a relevant disease to trigger these clauses, but this was narrowed by the Supreme Court, which held, as you'll see there, the first bullet point, on the correct interpretation of all the relevant clauses. They cover only relevant effective cases of COVID-19 that occur within the specified radius. The point was, if the clause specifies that it has to be within 25 miles of the premises, there has to have been a case within 25 miles of the premises, or the clause won't bite. But, and it's an important but, that doesn't mean that the level of cover only applies to the consequences of that singular case within the geographical area. I mean, we'll revisit that when we come on to causation. But in essence, significance should be attached to the fact that a notifiable disease is likely to affect a wide area. So notifiable diseases prior to COVID, for example, were things like yellow fever. And so it would be the expectation of a reasonable party that this disease may in fact impact a broader area than just the limited scope of the 25-mile radius. Interestingly, one insurer, and Kirsty will address this in more detail in her part of the presentation, had a significant 93-page exclusion clause, general exclusion document behind their main policy, which included a general exclusion for epidemic, which one would expect does actually contradict the fact you then have a main clause insuring for disease, and then you exclude epidemics. The court in this case said that was unreasonable and unrealistic. A policyholder would not understand, having read the main insurance clauses for disease, that they would not be able to rely upon that where the disease was an epidemic, where that exclusion clause is buried 90 pages into a 93-page general document. So it does also seem the court was quite aware that it was dealing with insurance policies for SMEs generally, and not tax or insurance lawyers used to leaving 93 pages worth of clauses behind an agreement. And so then moving on from disease clauses to prevention of access and hybrid clauses. Now, a lot of these talk about restrictions being imposed, which is the first question. And the second part of it, there was some dispute over what constitutes an inability to use as a result of restrictions being imposed. But looking first at restrictions, there was some debate, and the insurers tried to say, well, restrictions have to have force of law. If they don't have force of law, there's not a restriction. You shouldn't be able to rely upon any cover under this clause, simplifying it somewhat. And the court said, well, it's not really ideal, because what does that mean? It means that the policyholder, to make a claim, has to investigate the lawful basis of the instructions they're being given. So does this person actually have authority to tell them what to do? Does this have force of law? Is there a court order, for example? And let's say you have, for example, a restaurant in which the food inspector goes in and finds rats in the kitchen, and they say, right, you need to close immediately. Does that give them some leeway while they try and investigate if that has force of law or not? So it wasn't ideal. It also, for example, in this pandemic, would discourage people from voluntarily complying with measures meant to improve public health and protect the public as a whole. And so the last bullet point there on that slide is an extract from the judgment, in which they say it doesn't have to necessarily have force of law to be imposed as a restriction on the premises for these clauses to bite. So the instruction given by a public authority may amount to a restriction imposed if, from the terms and the context of that instruction, compliance with it is required, and it would be reasonably understood to be required without the need for recourse to legal powers. I'll stop here just to say this generally focuses on the Prime Minister's announcement on the 20th of March. So he went on television and said everything needs to close. But at that point in time, there's no legislation, no regulations behind that backing it up, giving it force of law. And the Supreme Court said, well, his announcement, his televised address, may be sufficient to be a restriction imposed in these circumstances. And as it goes on to say, this is likely only to arise in reality in emergency situations, as in the instant case. It needs to be mandatory, the instruction that's given, so businesses must close. but it has to be in clear enough terms that the person hearing that instruction knows exactly what is expected of them. And they were satisfied that the Prime Minister's address most likely did meet those criteria. So that's where we are interpreting those clauses. Where that leaves us in terms of causation. So let's say you satisfy the clause, you're within the clause. Does your loss actually flow from a notifiable event, for example? So in terms of disease clauses, quite sensibly, as I'm sure you will agree, the court said, well, the restrictions that were imposed by the government cannot be said to arise as a result of one single case of COVID-19. There are a vast number of cases, and that's the reason there had to be restrictions. That's why it was a national lockdown ultimately. One case couldn't be said to have caused the lockdown. And that's one of the deficiencies, the court said, with applying the But For test, because if the insurers say, for example, well, there was a test within 25 miles, but the interruption to the business wasn't a result of that case, it was a result of the cases outside of the geographical area, there shouldn't be cover. And the court looked at different examples, one of which was saying, well, the But For test would cause issues again, for example, in having a bus being pushed off a cliff by 15 people. And afterwards you have expert evidence which says, well, it only required 9 people to push that bus off of the cliff. And so 6 of those people would say, well, but for my involvement, the bus would still have gone over, so I'm not liable. And it just leaves an unsatisfactory result. So the court said, well, the But For test isn't always going to be appropriate and isn't appropriate for establishing causation in these cases necessarily. It's sufficient in these sorts of cases to view that all of the cases were of equal importance in causing the imposition of national measures. And therefore, if you have the one case, that led to the restriction. It's sufficient to prove that the interruption was a result of government action taken in response to disease, which included at least one case of COVID-19, and one case of that was within the required area. So that's where we are in terms of disease clauses. It's slightly more complicated in terms of prevention of access and hybrid clauses. In general, these tend to be a series of events that have to apply, each of which has to be specified for cover to then be affected. As I mentioned at the start, the issue we've got is 2 sets of wording. You have an inability to use is the main issue here. What constitutes an inability to use, and what is a restriction? Does the restriction have to be on the premises itself, or can it be a restriction affecting access to the premises? An example again the court looked at was, let's say there's a murder outside of a retail store. There's a police cordon stopping you from crossing that line, and that cordon is stopping you from entering the store. Now the store has restricted access, but the restriction isn't on the store itself, it's outside. And the court said, well, that will be prevention of access and would likely be covered. It would be unsatisfactory to say, again, with the caveat, this depends on the specific wording of your specific policy, that would restrict access. In terms of inability to use it, well, does that have to be a complete stop? You can't use any of the premises, or is it sufficient to say that access is restricted only to part of it? And Kirsty will come on to this, but in short, the court said there are 2 scenarios we have to look at in relation to causation. If you're able to use your restaurant, for example, for takeaways, but not for eating meals, then your loss would be related only to the part that you are unable to use. Or let's say you're a retail store, you're operating only click and collect rather than operating a general walk-in, customers can walk around the aisles and so on. You don't have a loss from walk-in business. And so in terms of causation, you have to really get into the nitty-gritty of what it is that has been interrupted and what the impact on the business is of that. So the losses stemming from the loss of eating meals, for example, rather than the takeaway that you're now able to operate. And then linked to that is the trends clauses. So the insurer's position, again simplifying it, is because of the wider consequences of the pandemic, insurers shouldn't be liable for policyholders for losses that would have arisen anyway. So people stopped going to pubs before the lockdown. There was then a national lockdown. They would have suffered those losses anyway, and so the insurer said, well, we don't want to pay out. The quantification of loss should take account of the fact that they would have suffered those losses in any event. And the court said, well, we do appreciate there are uninsured losses and insured losses, but here all of it relates to one underlying issue being the pandemic. So trends clauses are part of the machinery for quantifying loss. That's the purpose of them. They aren't aimed at addressing the scope of the liability. They shouldn't be used as a way of excluding liability that outside of what the purpose is of the main insuring clauses. And so they should be interpreted where possible in line with those main insuring clauses. And absent any clear wording to the contrary, insurers can't reduce indemnity on the basis that losses were caused equally by other uninsured perils with the same underlying clause. I mean, here, interestingly, there's talk of this pre-trigger issue in the judgment, which is, let's say you have a downturn in business, people stop coming to your business prior to the lockdown, and so you suffer a lot of profit. If the insurers were trying to say in the case, well, that should be taken into account as a downward trend for the purposes of quantifying the loss. And the court said no. Again, absent any specific wording, that was said that it was a result of the same underlying cause. It was all the result of the pandemic and shouldn't be a way factored into quantifying the loss that then follows. So that's the case, and where we are on the case, a broad overview, wishing through that. Kirsty's now going to take us through what the actual knock-on impact of that is for cases that may come to you.
Thanks, Natalie. Right, so we're going to talk about practical implications of the case and sort of the observations that Natalie and I had when we were going through it and discussing it. The most important point, I think I would say, is that this is not a one-size-fits-all case. So the insurers and the policies were chosen by the Financial Conduct Authority on the basis it was thought that they were the widest group of policy wording and would cover most scenarios, but that cannot be guaranteed. So it's imperative that this case is used as a guiding principle, if you like, to the policy that's in front of you. So always carefully consider the policy wording and any specific caveats or any specific definitions that have been given in that policy. The overriding point throughout the judgment, and the Supreme Court was really keen to stress this, was that the basic principles of contract apply. What would the reasonable person reading this policy have expected the wording to mean at the time they entered into it, with the knowledge that they had at the time? And that leads us nicely onto the exclusion clause. So Natalie picked on it very gently when she was going through the case. And as she said, there was one particular case, one particular policy rather, where within a 93-page document, there was an exclusion clause hidden at the back. The policy had stated you will be covered for any human contagious disease, I think was the wording. And then buried at the back in an exclusion clause was you will not be covered for an epidemic. And the court said, no, that's unacceptable. If you're going to exclude something, it should be very clearly expressed at the point in the policy that it is most relevant. So for example, if you're going to exclude something in the disease section, make it clear. That particular policy, and actually all of the policies, made it very clear they were not covering for AIDS, for example. And the court said, well, if you're not going to cover for an epidemic, why isn't that here in this policy? The reasonable person of an SME business, a director, wouldn't have gone trawling through this document to try and find those exclusions. It had to be clear on the face of it, which is an interesting point, and I think actually is a point that might lend itself to other areas of contractual interpretation going forward. So we might see people picking this point out that the Supreme Court has given and using it going forward for other contracts and other insurance policies. So it's just a useful point to know, I think, going forward. But what does that mean for you as the lawyer? Should you be hunting through this policy document just to see what those exclusions are, or should you just turn a blind eye to them in the hope that this principle that the Supreme Court has given will cover you? Well, our view is actually go and hunt them down, go and know where they are, go and know what they say. You've got a much stronger argument if you can say, well, this is a 100-page document and this is on page 98. Whereas the principles are on page 2. And frankly, who's going to sit and read all 100 pages of this? So just have that in your armoury. Restrictions. Know what the restrictions are in this policy that you're looking at. So I've heard someone who'd contacted Chambers and was after some advice in respect of their insurance policy. unfortunately, they only had a limit of £25,000 on that policy, which was absolutely heartbreaking for them because their loss was much more than that. So know how your level of insured risk is set out. Is it for a fixed amount, or is it an amount relevant to turnover? And this is where the trend clauses come in that Natalie touched upon. And yes, the court did say, well, so taking that example Natalie gave of the pubs, Boris came out and he told us way before the official national lockdown on the 23rd of March, pubs should be closed. But prior to that, he'd been saying to us around the 16th of March, restrict your movements, restrict your contacts, stay at home. So in that week between the actual guidance, if I can call it that, and the enforcement, pubs were saying, well, our turnover is down by 70%. And the court and the insurers were trying to say, well, we shouldn't have to pay for that week's loss, because it doesn't necessarily arise out of that explicit instruction that they must close. And as Natalie said, the court said, well, no, it's linked to this pandemic. So actually, yes, you should be covering it. The trend clauses, I'm sure some of you are familiar with it, they will look at assessing a loss over a period of time. Usually it will be the 12 months prior to the insured peril happening. So, and what normally happens in those clauses, if you have a seasonal business, for example, a holiday rental or something like that, it can factor in your proper loss, if I can term it that way, by looking at the trends that you have in your business over the period of the year. If your business had been struggling in relation to something not connected to COVID in the year before, then again, that trend is going to demonstrate that you've had a downturn in business for other reasons. And the insurers will quantify your loss in respect of looking back over that year. However, what they can't do is pick out, as I say, that 1 week and say, well, that's significantly impacted. The court have said, no, anything that is connected to COVID, you can't ignore that. But we understand that anything not connected, so if there'd been a downturn in business anyway, yes, you can use that in your calculation of loss. And the other point that Natalie touched on as well was she was discussing, and the court used this as an example actually. They used two examples, one of a bookshop, for example, that previously had walk-in trade only, but then they developed a click and collect service or an internet service to reduce their losses. And also they used the example of a restaurant which had only been dine-in previously, but during the pandemic had created a takeaway business. Now, when you're looking at quantifying loss, you may have mitigated your loss, your clients may have mitigated their loss by setting up these other arms of their businesses that they've not had before. What the insurers might need you to do is split out your revenues for the trend. So can you show us for example, where you have a dine-in only restaurant, it'd be quite simple to show our dine-in is 0 and our takeaway is X. That will all be taken into the round. But if you have a restaurant that did have a dine-in and takeaway previously, what you may then need to be showing with your clients is, well, our loss in our dine-in is 100%. We've lost all of that revenue. But our takeaway, so you do need to demonstrate and be able to demonstrate with your clients those separate revenue streams early on for quantifying loss. And just one other thing that we wanted to touch on was, what about disruption in a tier system? So most of these cases, in fact, this case focused on what was the first national lockdown. That's how it arose. But then we went into a system of tiers, as I'm sure we all remember. And there's absolutely no discussion of the tier system in this judgment in the Supreme Court, despite the fact that it was after we'd entered into the tiers. Now, I suspect the areas that Natalie touched on in terms of the geographical areas and the points that the court were making, well, actually, you can be affected by a contagious disease outside of your 25-mile radius. I suspect what would happen if someone did argue it on the tier system is that those principles would apply. There's still a national problem and there were still restrictions applied nationally. So I don't think an insurance company would be successful in arguing these geographical restrictions. And that means, well, you're in tier 1, for example, so therefore you had less cases of COVID in your area and therefore you shouldn't be able to recover your losses. I don't think that argument's going to work because of how the Supreme Court has worded their judgment. It's a national problem. We were all in some way restricted and had some restrictions applied to us. In terms of the restricted access clauses, again, because a restriction to close, so for example, those in tier 3 or later tier 4, pubs and restaurants and some gyms in tier 4 were asked to close. That is something, well, they weren't asked to close, they were told to close. That is something that was enforced by the government. So again, I think there's going to be no difficulty in claiming under those restricted access clauses. So it might be a case of looking at that policy if you're making a claim under the tier system, looking at those policies and saying, do you have a disease clause or do you have a restricted access clause? Which one is going to be best to go under? Do you go under both? And just weighing up the pros and cons of each of those approaches. Now, I say this, but I don't expect there to be a lot of claims under the tier system because I think a lot of loss did arise in the first national lockdown. And I think anyone who has this business interruption insurance may have made that claim in the first national lockdown. So there may be a restriction then on making a separate claim for the same insured peril. So I don't know how much we will see of claims under the tier system. But I should expect insurers might try and put up more of a fight, but I think the Supreme Court did cover it off quite nicely with their reasoning. So that brings us to the end of what we wanted to say on the case itself and sort of our observations. The main takeaway from both of us really is just read every policy that comes across your desk really carefully, assess it on an individual basis using the principles of the test case as a guide. Natalie and I are both now au fait with the Supreme Court judgments, having read it and discussed it. So again, if anyone has any queries or questions that they want to ask, then Natalie and I are more than happy to answer those. So without going on any longer, we would like to open the webinar up for any questions that you might have. And I can see a couple have popped in whilst I've been talking.
Yep, so I'll give you a chance to read those, Kirsty. I read the first one, so I'll jump on that. So whilst this case only deals with business interruption insurance policies, do you think it will have an effect on other insurance policies, for example, travel insurance and wedding insurance? In short, yes. They are general principles that apply to interpreting insurance policies generally. It's quite likely that similar wording would have been used because they're general insurance policies, whether it's business interruption or otherwise. Again, with a caveat, it will depend on specific policy wording that you're looking at. But yes, those principles should apply more generally across other similar wording in other policies, wedding policies or holiday or otherwise.
Yes, and I think the exclusion clause thing is one thing that probably keen to pick out on, because I think a lot of people with holiday insurance were getting caught out where much further on down the document there was an exclusion for pandemics, for example, and I think that is a point that is going to come out and I think is going to be really useful for other insurance policies. If it's clear on the face of it, and I suspect going forward we're going to see a lot more insurance policies that are very clear on the face of it and expressly put those sort of straight in your face when you're signing up for things. But I had to have an argument of my own insurance policy, actually, which did have it very much further down. Unfortunately, this judgment wasn't out at the time, so it didn't help me very much. But I think with holiday policies, yes, it probably will help. Yes, if anyone wants any opinions on any particular policies that they've had before them, then do get in touch with either Natalie and I, and we can discuss sort of timeframes or costs of doing that. But if you drop us an email, if you've got any particular policy, then we're happy to have a look.
So the next one was the Supreme Court, when assessing the words inability to use due to its restrictions imposed, says it would be rare when liability would be found if the business was classified as either a Category 3 or a Category 5 business, which is those businesses that were allowed to remain open or were specifically forced to close by the 21st or 26th of March regulations. What do we think these rare situations are where they would be covered for closing? There's one example would be they had a specific case in there and their staff, for example, and they had to close. I think that's the point. The purpose of rare is, well, they don't want to say never, but it's going to be very fact specific for those businesses. Were they allowed if they're allowed to remain open, then there wasn't an ability to use it. But if those specific circumstances meant they couldn't, so for example, their staff were all off, potentially that could be argued, but it's going to depend very much on the wording. And if Kirsty's got a different opinion.
No, I agree with that. Just for those of you who haven't read the whole of the judgment, the Category 3 were food retailers and pharmacies, and Category 5 were professional service firms, so solicitors. So I think actually, Natalie, particularly with Category 5, has hit the nail on the head. If there's been an outbreak of COVID in that establishment, because what the court was saying was, well, actually, many of these professional services firms were able to continue, so there was no loss to them because people were working remotely. Okay, the next question that we have, would you agree that the Supreme Court judgment does not assist where a policy covers an express list of diseases which is not wide enough to incorporate COVID-19 or notifiable diseases? Oh,
Isn't it?
Yeah.
Okay, it's the usual typical lawyer, isn't it? It depends. So if it's notifiable diseases and it refers to the list of notifiable diseases that is published, then COVID-19 is on there. But it depends if notifiable diseases in the policy is at the date of a certain event and it wasn't on the list at that time. In terms of, sorry, go on, Kirsty.
I also think it depends how that express list of diseases is stated. So, for example, you could have whether it might say swine flu, for example, or whether it says respiratory illnesses. So I think it depends how that's expressed. Sorry, Natalie, you were going to say something else.
No, it's completely escaped me, but I agree with what you said. It does depend how it's defined. Not why I don't think of it. Yeah, it's just going to depend on the policy wording, isn't it? Ultimately, how have they done it? Is it including these diseases? Is it only those diseases? Is it exclusively these diseases? So just going to depend on the policy wording.
Okay. There are all the questions that we've had pop up, but as I say, if anyone has any particular queries that they would like to run past Natalie or I, you can get in contact through us with us via the clerks, or you can email us directly if you want to. But thank you very much for attending this morning, and we hope that it's been useful. So thank you very much, and we'll let you all get on now with your mornings. Yes.
Thank you, everybody. Enjoy your Friday.